The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and thank you for joining us for today's webinar, Dealing with the Sticky Issues for the Industry. My name is Sarah Haberman, and I'm the Customer Marketing Specialist here at BULLHORN UK. Today's webinar is the second in our three-part series addressing the changes to European legislation coming into effect in May of this year. Today, I'm joined by our presenter, Lucy Kendall from Comply GDPR. Lucy brings 17 years of experience leading and developing executive search, interim management, recruitment businesses, and in-house teams, and has since joined the team at Comply GDPR. Lucy is focused on helping recruitment agencies embrace and align with the General Data Protection Regulation. Before we jump into the webinar, a few housekeeping items. Today's session is being recorded and will be shared with you. All of today's content is the intellectual property of Lucy and the Comply GDPR team, so please do not share the recording outside of your own business. This is the second of 3 webinars that are aimed to help you understand and prepare for the GDPR, but BULLHORN and Lucy do advise that you engage with either your legal teams or a specialist like the Comply GDPR. The webinar will last for approximately 30 minutes to allow for as many questions as possible. Questions can be submitted using the questions pane in the menu. That's enough from me, so let's pass things over to Lucy.
Hi there. Hi, everybody. Thank you for joining us for the second part of this webinar series. I am going to try and be careful about timing. The one we did last time has got a lot of ground to cover, so we didn't have as much time for questions, so I'm going to try and be very disciplined this time so we get plenty of time at the end to open things out for discussion. So I guess out of the 3 webinars, this is the one which this is about really sort of diving into kind of some of the issues that I think probably a lot of people that have read up on this and are starting to do some work around it have perhaps got to and finding it a bit challenging. So the idea is that we dive into some of these and just I'm going to try and give you a bit more clarity and just try and get you to understand the sorts of things you need to be thinking about. So really quickly, let's get this, there we go. So for those of you that listened last time, you'll know a bit about me. I hate to say a slight veteran of the recruitment industry, having been in it for a wee while now, and I've worked across most verticals. Worked in global environments. I've worked for myself, I've worked for a US listed large contingency firm. I've worked in search latterly, and on that journey I've had to do lots of sort of quite chunky change projects that impact the industry. So this kind of how I've ended up in the GDPR space. So it's really just to say to those of you listening that don't know a bit about me, I really do, and my career has been in the recruitment sector, so I empathise with the journeys that you're all on. So what we're going to cover today is I'm going to do a really quick recap, and I'm going to do that because what we're going to talk about stems from some of that recap. And then the sticky issues or pain points that I've picked are these. I hope that they do resonate with you, and these are things that you are sat there going, oh, what do we do about these things? So yeah, so we'll crack on because we've got a bit to get through. So just from a recap perspective, it's just a reminder to everybody that this is a human rights piece of legislation. It's coming into place to protect each and every one of us. So I like to say this just to remind everybody that when you're feeling ever so frustrated in your organisations with the journey you're on, it's just to remember it is designed to protect each and every one of us and the data that relates to us, and what businesses then and organisations do with it after they've acquired it from us or borrowed it from us. So I think I also explained last time a bit about the fact that this is here to address this power imbalance between organisations and the likes of ourselves, and it's just really about trying to balance out that seesaw and moving from this mindset of the fact that everybody thinks that once they've got personal data they can do what they like with it, and it's this law saying, hang on a minute, that's not the case. We need to get the power imbalance addressed. So as we go through this presentation, I'll refer back to this sort of power imbalance and how it relates to some of these sticky issues. So I think we talked a bit last time around the rights. So at the centre of the GDPR is the fact that each and every one of us has a right to exercise control over how our data is used. These are all the things that we have a right to do. I said last time they're not all absolute, so we don't all have them immediately. They're linked to what we're calling the lawful basis of processing, which is first up on our sticky issues that we're going to talk about. But these are the sort of superpowers that we have in terms of how we can exercise these rights to control the use of our data, that what other people are doing with our personal data. And the other thing that underpins the GDPR, so you've got the rights that we have, and then you have, if you remember, I talked about spinning plates. So the spinning plates are the principles that underpinning current data laws, and continuing on then with GDPR are a suite of principles. And what we're going to talk about today links into these two veins that sort of thread through the GDPR. So you know, just very simply, we as organisations that process data, we have to live up to these principles. So we have to be lawful, fair, we have to be transparent, we've got to use data for a specific purpose. We shouldn't record things that we don't necessarily need to be recording, so we should only process what we require, which is the adequate, relevant and limited. We have a duty to keep it accurate. We should only keep it for as long as we need it, and obviously we should adequately safeguard it. So these are the principles, and what we're going to talk about today will link back to the principles. So the first one I said we're going to talk about is the lawful basis of processing. So this is first up on the list of the spinning plates list. So, and specifically, there's a lot you could say here, but what I'm going to do for this session is talk about legitimate interest versus consent, which some of you will have heard lots about. It's just to explain that if we start with, you've got to pick your lawful basis of processing. So there are 6 reasons, 6 lawful bases that you can pick between. So here they are displayed in a cartoon. So you've got to decide which one is relevant. And we typically say that 4 of these are at play in a recruitment business context. Some of them, such as contractual necessity and legal obligation, are linked to your employees, or if you're payrolling temps or paying interims. But the 2 that we're going to focus on are really the 2 that I think probably people are most confused about. But also I'm just going to give you a bit of an indication about what you should be thinking about when you decide what it is you're going to select for your business operations. So I'm just going to talk about recruitment activity in general here. So the process of either helping clients to fill a job or helping a candidate find a job. So for those of you that aren't familiar, legitimate interest, is legitimate interest appropriate? So legitimate interest is about the fact that you as a business, or we as an industry, have a legitimate interest in processing personal data to achieve a business end. So if we go back to the power imbalance, the key thing about legitimate interest is you can't use legitimate interest unless you can evidence that you've balanced out whatever that legitimate business interest is for you against what's the impact likely to come to those individuals whose data you're processing, their rights and freedoms. So the seesaw analogy is quite prevalent really throughout a lot of the GDPR, and this is sort of how I describe it, that when you think about what we do as recruiters, you've got to think, is that an activity that the individuals that we work with, are we harming them in the activity we're doing? And would they expect us to be doing what we're doing? And you've got to weigh the 2 up. So, you know, in a very simple way, the way I look at it is that, you know, if a candidate is looking for a job and we're able to help them find a job, then to me, without going into any detail, I feel like the seesaw is quite balanced. But the key thing about legitimate interest is that as a business, if you rely on it, you've got to evidence that you have thought about both the activity that you're doing and what the resulting consequences are to the individual. So the key thing about it is that you can't just go, brilliant, I'm going with legitimate interest. You've got to actually say, and evidence in some form that you've considered your business interests on one side and the individuals on the other, and that you've evidenced that it's balanced. So you know, I think, and there's an increasing trend throughout the industry, this is an appropriate lawful basis for us. The confusing bit is consent, and I could spend half an hour talking about this, because the word consent is just, unfortunately for us, is linked to a number of different, I suppose, aspects of what we do. Consent, if we talk about consent under GDPR, the thing that you need to know is very intentionally under this legislation, they've made it a harder lawful basis to sort of secure. So consent's got a higher standard under the GDPR. So you might be processing data, or you might have historically processed data under consent. You may have even been processing your staff's data under consent. So have a look at your employment contracts. But consent is actually meant to be a very sort of strict, it's basically very, very hard to get it, and it's incredibly hard to keep hold of it. So I think it's just that there's a blog here that, and I know there'll be people here listening from other countries outside of the UK, but for those of you within the UK and for those of you outside, do have a look at your, you know, local regulatory body. But there is a really good blog article about, directly from Elizabeth Denham, talking about that consent is not the silver bullet. So, you know, be very, very careful about whether, you know, about the role that consent has within the context of recruitment activity. So it's just something for you to think about. And when I talked last time about the rights, if I just go back to this, when I said to you last time, and this time I've said the rights are linked to the lawful basis, the key thing about consent is when you process somebody's data with their consent and under the lawful basis of consent, the individual gets supercharged powers. I mean, they have the right to all of these things that I'm on screen at the moment. So in a practical sense, as an agency, if you got somebody's CV at 2:05 on a Thursday, and somebody gave you their consent, at 2:10 on that same Thursday, they can take that consent away. So the power is wholly with the individual. So it's just really to stress that. Okay, so we're gonna talk about transparency next. So the thing with transparency, this is quite an interesting one for us as an industry, because I'm not entirely convinced we're the most transparent. But this is at the spinning plates. If we go back to the spinning plates, so transparency is sits in the same sort of plate as lawfulness, fairness, and then you've got transparency. So what does transparency mean? So I say it's a new kid on the block. That it's possibly a bit of a provocative thing to say, because transparency is present in current data law, but what they've done is they've really brought it to the forefront. So the bottom line is really what this cartoon says, which they have gone to great lengths to basically say, if anybody out there has our personal data, we have an absolute right to be told about it. So when you put that into the context of our industry and the fact that we acquire CVs off job boards, we acquire data off LinkedIn, and we just kind of do it because we want to build a knowledge of our market, or we want to just have a really good pool of candidates when we get that temp job on. You know, this is that when we do all that data gathering, you know, the game changer here is that you absolutely have to have a way of communicating within a set, so there's a set time period, and it's pretty robust, that you've got the data. So just before Christmas, there's a thing called the Article 29 Working Party. They are a population made up of representatives from European countries, and their job is to help take the law in its black and white form and interpret it for all the countries in the region. And they sort of go through each section bit by bit, and they release their final guidance before Christmas about transparency. And I think that, you know, if you do read broader articles about GDPR, it really is about the fact that the trust has completely gone between organisations and individuals. So the transparency element, they just reiterate, is that it's about engendering trust, and so that people, if they want to, can challenge and exercise their rights. So this lawfulness, fairness and transparency bit, it all does sit in quite an interlinked way. So it is about being fair. If people don't know that we have their data, then they absolutely cannot have any control over it, and that isn't fair. So so transparency now under the GDPR is a fundamental aspect of the principles. So it's just to explain to you about that. The thing to say, which I'm sure will start a lot of questions with people, but you know, in terms of the timeline, they have absolutely confirmed that if you collect data from wherever the source may be, so job board, LinkedIn, referral, whatever it might be, you have to communicate within 30 days to the individual that they've got their data, or before, if you're going to share it with a third party. So without sort of overloading everybody with lots of information, but this is the transparency requirement. So this little chart here is just showing you what it is you now have to communicate to every person that you've got either on your database or everybody that you're now going to collect data on within 30 days. This is what you've got to communicate with them. And obviously there's quite a lot of circles there with quite a lot of information. The thing just to say to you is that this is the information that needs to be contained within your privacy policy. So your privacy policy is really important, because it's the vehicle for you to be able to get this message across and hit the transparency requirement. So yeah, so it looks like a lot, but it can be achieved in quite a streamlined fashion. So but you do have to be absolutely clear as day about it. Okay, right, so accuracy, again, another one of my favorites, because obviously we keep everything up to date on our databases all the time. So really just to say about this, why is accuracy important? So if we look at it from a different angle, it's that people and their circumstances change. The longer that we have somebody's personal data and you've not updated it, the harder it is to argue legitimate interest as your lawful basis. So if I just go back to that seesaw, if the timeline goes on between your last contact with somebody and you've completely lost, you know, you spoke with them 8 years ago, they were in a certain role, they're now a managing director, or they're now a head of, or you know, they're now in a very different role. If you're trying to argue legitimate interest that your seesaw is balanced, you would start looking at that and say the seesaw isn't balanced, because actually those individuals are being negatively impacted by the fact that you haven't kept their data up to date, and perhaps you're not considering them for an appropriate role that you may be working on. You've got data that's completely out of date and doesn't represent for who they are today. So I have had loads of conversations with clients about this who grapple with why they've got to keep things up to date. And the only thing I can say to you is that the way I sort of think, I mean, I've got a bit of a fairness radar where I start thinking, you know, how would I feel if I were in that position? And I just think, you know, in my career, I've met lots of different people, interviewed lots of different people. I think, you know, imagine meeting a sales manager who's going through a very, very difficult time in his personal life, and I meet him at that point. His sales figures are down. He's missed, you know, he's off track from he doesn't get his OT for 2 years. And he's really not performing well in his job. But whatever that personal experience he's going through, that isn't going to define him forever. That's a point in time where he's struggling, and it's just, we've got to remember that we have a duty in our profession to keep up to date with people so that we can best represent them, that we can best service our clients. So there's lots of other examples I could use there, but it's just try and think about the scenarios that could play out if you don't know what somebody's current sort of circumstances are. And I say current in speech marks because, you know, I'm not sort of saying that, you know, it's like a weekly, monthly thing, but it's just for you to be aware that it's something that we as a sector that they, you know, this is something they're not going to like about our sector. There is a risk of discrimination. I think one of the things that's quite interesting here to flag is, of course, your relationships with job boards, and we're still all waiting with bated breath, I think, to see exactly how job boards are going to, how things are going to play out here. But when I used to access job boards, which was a very long time ago, but you know, if you go on a job board and you're collecting data from there, if that data hasn't been modified by the user for 5 years, and then you take that data onto your database, the problem that you have is that you've now picked up data, put it onto your database, and it's already 5 years out of date. So it'll be interesting to see what the job boards do about their data retention periods. But I think it's just to flag to you that just being really careful about what you're collecting and whether you're already on the back foot at the point of collecting it. So yeah, just a couple of things to flag. I'm just trying to think if there's anything else in this section. Yeah, so this is sort of just, we're going to lead into data retention next, but at Bullhorn Live, it's just to say when the ICO, which is the UK's regulator, spoke there, they did talk explicitly about discrimination. So it's definitely something to think about. And I think this sort of cartoon, I've definitely worked with quite a few businesses who are like, you know, information is the most important thing. Just keep, you know, pouring it into our system. You never know when you might need it. And sadly, what's happening for us, although I do think I think it's a positive thing, definitely, but you know, it's just, you know, we are going into this realm really of accuracy, then having a fundamental part to play around data retention. So we've all got to accept we're going to be changing, and things are going to be different in the future. But you just can't keep the data for as long as you want to keep it. You've got to have a logical argument, and you've got to keep it up to date. So that's how the two things dovetail. Okay, so going on to data retention, what did I want to say here? Okay, so you basically, we are now in a situation where we've got to start understanding about what personal data that we have. So when we talk about what personal data do we have, or we're processing, this might be, you know, you've got it, you are holding it somewhere. You might be doing something with it, you might not be, but you've got it within your business infrastructure. So, you know, this what I've done here is to try and sort of provoke some thinking around how do you tackle the legacy data that you've got. So we always start with our clients with a, you know, what personal data do you have? So, you know, this could be CVs, copies of passports, contact details, and then obviously what different types of people have we got that data on? So you've got clients, candidates, employees. So you have to kind of build this picture of all the different sorts of data that you've got, and in what forms. So, you know, we talk about databases, but you know, you've got shared drives, emails, hard copy, lever arch files somewhere, or papers on desks. Anything that's got some structure to it is included and protected by GDPR. So then working out where it all is, which on the face of it might seem quite simple. In reality, it's actually it's on my kitchen table, or actually it's on my mobile phone because I took some pictures of somebody's passport. Actually getting an understanding about where you as a business, but also your staff who work for you, who you're responsible for, where they've got everything. Interestingly, who's got access. So really common. Yeah, all our HR files are, you know, protected, password protected. Finance and HR just have access. But actually, until you start sort of delving into it, you'd be quite surprised who's got access to what. You know, there's, and if you think of the sensitivity of the information, so if you think somebody's passport, the risk of identity fraud, and you know, you might find that somebody's just got copies of people's passports on their desk in a lever arch file. So, you know, you've got to start understanding, you know, who can access things. And of course, when we talk about who can access, it's that lever arch file with all the passports in is available then for your contract cleaners who come in and clean your offices when you're not there. So some of this stuff, you know, it starts giving you a sense about some of the risk. Where did you get it from? So again, you've got to start doing some analysis around, did you get the data from a lawful source? So, you know, and there's lots of things I could say around that, but you've got to be comfortable that the personal data you're processing has been acquired lawfully. And then, of course, who you share it with. So your first step in dealing with your legacy data is that you've got to understand what it is that you're actually dealing with. The next thing that I say is, how old is it? So how old is your business, or how old is the journey of that data, and when it was last updated? And definitely from a CRM perspective, these are things that you want to speak to your CRM provider about, to see if they can help you segment up your data and understand some of these things. The next thing, which is a bit like the security blanket for recruiters, and I think that this is probably one of the things that this is about, you've got to let go of this, which is, why are you keeping it? And if you ever try and ask a recruitment business to delete its data, or certainly in my experience, nobody wants to delete anything, because you might need it. And if you delete that one thing, you're going to need it next week. But we're going to have to let go of this. You've got to start thinking about what are the reasons for you keeping the data, and do you need it? So I think the next slide, I'm going to talk about some of the things you might think about around that. I'm not talking about you getting rid of data that's valuable to the business. I'm talking about you getting rid of data that doesn't hold that much value, or perhaps doesn't hold that much value in relation to the risk of you carrying it. And really then the last thing is linked to that what you all need to know is that data is going to become part of a conversation around value, the value of a business. It's going to become part of it's going to be at the negotiation table at the 11th hour. If you ever want to sell your business, merge, have investment, they are asking these questions now. Do you have dirty data? Do you have healthy data? So really simply, the data that we process and develop, and the talent that we're connected with, and the networks we've got that we all say is an asset for our business, it could just as easily be a liability. And when we talk with our clients about legacy data, when they're working through what they're going to retain and what they're going to get rid of, we always ask them to think about the spinning plates. So when they're thinking about the decisions they're going to make, you've got to ask, are your plates still spinning, or are they on the floor shattered? So for example, if you're deciding what to get rid of and what to keep, you've got to think about accuracy. And if you're saying we're going to keep everything, we're 15 years old, we're going to keep everything because we just are, the accuracy plate is going to be on the floor. So you just need to make those decisions in the context of what the GDPR is asking of you around its principles. Okay. So marketing, which I'm sure is a popular topic. So what do I want to say about marketing? It's really just to say there are two pieces of legislation that govern cookies and direct marketing. The GDPR does have something to say about it, but the key piece of legislation is the Privacy and Electronic Communications Regulation. Currently going through European Parliament is the e-privacy regulation, which will come out and will replace this current law. Which I think I might have said in the last one is slightly terrifying, but I'm pretending it's not there for the moment, because it could really change how we conduct new business activity and things. But for now, this is what we've got. So the key message is really to say is that the GDPR obviously says that you shouldn't use data for other than the purpose of which it was collected. So when we do get somebody's CV and we aren't successful in finding them a job or the temporary appointment, we can't just suddenly start sending them mail shots, because that could be perceived to be a form of marketing. Or the same with a client. A client says, can you help us with this temp job? And then before they know it, we're speccing in CVs and candidates of all natures for their business. So it's not that you can't do it, it's just you've got to be clear with people that this is what you're intending to do with their data. So again, that's a privacy policy issue. So links to transparency. So again, you've got to be clear with people what you're going to do with their data. And the GDPR says you've got a right to object to marketing. So people can say, which I'm sure you're all used to having candidates or clients say to you, please don't send me details, I'm fine at the moment, or so that's a legal right that people have. The Privacy and Electronic Communications Regulation, it's a slightly complex topic in that there's what it says in black and white, and then it's how they regulate around it. So what I wanted to really get across here is the importance of you listening to people. So there are checklists available that you can go read up on what it is you should be doing. But I think what I just really want to stress to everybody is that you've got to give people the right to opt out, to unsubscribe, and you must listen to them. And if you don't listen to them, or your staff work around the databases, do not contact, or whatever it is, you are likely to face, you know, consequences for that. Now, those consequences will vary upon which European country you're in, or which country you're in, because each country has a different tolerance level for marketing. But typically, I've heard examples in the UK where people will be phoned up. So I'm sure you will have seen there's been slating on LinkedIn. I've definitely seen lots of slating on LinkedIn about people saying, you know, I've asked to be taken off the mailing list from this recruiter, but they keep sending me jobs, and normally they keep sending me jobs and they're the wrong sort of jobs for me. That's the sort of activity the regulators are not going to like. So, you know, I think it's just going back to the fact that, you know, this is a human rights piece of legislation. If people say, please unsubscribe me, please don't contact me, we've got to listen, and we've got to then manage that moving forward. So something to think about here is, if you use a system like Bullhorn, but you use a separate system for marketing, you need to look at, so your marketing MailChimp system might be brilliant. It might have all your unsubscribes, and what you send through that is, you know, is perfect because you've got your unsubscribes. But if those unsubscribes are not correlated with your database, then you've got the chance of upsetting people because they're not talking to each other. So that's definitely something that I'd take a look at. Okay, so the last one is accountability. So it's not really a sticky issue, so it's probably wrong to call it one, but it's one I just wanted to stress as we come to the end of the presentation, and that is, you know, just please remember that any work that you're doing around this project, record everything, evidence everything, and be ready to have you know, a booklet or a file that demonstrates to the regulators that you are taking data privacy seriously, and how are you complying with the GDPR. So it's I sort of said this last time, this is a change. This doesn't exist today. This is about them making us accountable and evidencing how we're complying with data privacy laws. So this is the new thing. You know, we have to be able to show this. If a breach occurs, which is highly likely in the reality of what we do, you need to be able to say, these are the rules that I put in place. These are all the safeguards I've put in place. This is how I'm complying with the GDPR. Here it is, read this document, or you know, have a look at this file. And the other thing you need to say is, I've trained everybody. As a business owner or a director, we've trained everyone, and they knew what they should have been doing. They knew what their responsibilities are, and that's how you'll defend yourself in one of those situations, which is quite likely to happen. So these are the sorts of things. It's the accountability principle. This is what it talks about in terms of how you demonstrate you're complying. So yeah. And data protection impact assessments, much like a transport impact assessment or an environmental impact assessment, that is when you're going to do something that could put the individual's data that you're processing at risk. A good example would be a migration of a database. You know, you need to do a data protection impact assessment just to ascertain what could go wrong, and if it goes wrong, what can you do about it. So you just need to, again, it's all about showing your workings. But you can just see these are the things. I thought I'd flag that one because I'm not sure I've spoken about that before. Okay, so just finally to wrap up, everybody's that's heard this before. This is myself and my business partner Helen. This is what we do. We work with the industry to support it on its journey. This is what we do. We work with CMS Law. So Elle Todd, who's pictured there, she's head of data privacy for CMS Law, and we've created a solution that supports businesses on this transition, and providing them with all the things that I've spoken about in terms of the data protection handbook, and yeah, just giving you a really practical step-by-step guide to get match fit for the 25th of May. So and I do this every time. I always finish on this because I think, as much as it's a lot to do, and it is, and we've got to we've got quite a lot to get our heads around. I think it's just really important that everybody really understands. It's about, you know, getting yourself sorted, moving forward, evidencing you're trying, and if you can demonstrate that you respect, value, and protect people's personal data entrusted to you, you'll be in a good place. So there we go. That's me done. This is what's coming next. So I don't know whether Sarah wants to hop on now, but the last part of the webinar series is going to be on risks. So I'll just explain quickly what I mean by that. Is that there's definitely a part of the next session which is going to be around, you know, from a business level perspective, what are the consequences? And it's sort of deviating away from the headlines of the fines. I'm going to talk about, you know, just day to day, the reality of kind of what could cause you issues if you work in the sector, and just to give you some examples really of day to day things that, in fact, every example I use, I've either done or contributed to. So I just show you the things that could really go wrong, and actually then how you'll be able to defend yourself if you've got the right things in place. So and then of course taking this as an opportunity to get your businesses in better working order. So yeah, that's part 3. So I think we're going on to questions now, but thank you everybody for your ears. Hope it's been useful. So I think we're now going to Q&A. Sarah, are you there?
Hi, Lucy, can you hear me?
Yes, you're there. There we go. I was slightly anxious then. I was like, where's she gone? Where's she gone?
No worries. I think Sarah was having an issue with her audio, but that's fine. We can definitely jump right into the questions. Thank you again for the great presentation. I think this is a great kind of progression of what we discussed last time. And a couple, just to kind of head this off, a couple of the questions we saw right off the bat were where people can find part 1 of the series. And I just wanted to let everyone know that if you go to bullhorn.com/UK/GDPR, we put together a really nice repository of a bunch of helpful resources specific to GDPR. And one of the ones listed is part 1, the recording from part 1 of our series. So you can find that there. And we'll put a reminder in the follow-up email as well. So one of the questions I saw here from Anna for Lucy is, I've listened to and read copious amounts of stuff on GDPR, but where can I go to find the practicalities of writing clauses, where to add them, how to market to new clients after GDPR? Lucy, do you have any thoughts on places where she could get this information?
Yeah, I mean, it's really difficult for, I mean, it's why we set up our business really, is exactly because we could just see that there wasn't a vehicle out there that was giving people clarity. I think one of the challenges we have as an industry is we're relatively unregulated. So I guess other industries have had their industry bodies be involved, you know, sat at the table with regulators talking about the needs of their industry. And sadly, I might be speaking out of turn, but I don't think I've read some detail, but I don't think we've had the representation. So the consequence of that is that we haven't got sort of a cohesive, you know, guide coming out of anywhere specifically. I think it depends where the person asking the question, it depends which country they're in. From a UK perspective, there are various bodies like APSCO, like REC, who have, I understand, produced some form of toolkits. I don't know how comprehensive they are. So the reality is your options as a business are, you can go and talk to a lawyer, perhaps try and find one that does understand the recruitment sector. So there are some that work specifically in the sector. You know, your options are then to go to your governing bodies. If you're paying membership fees, go and find what they are prepared to give you as part of that. The other thing is that then there are consultants out there. So, you know, our whole business is set up on a service that is about giving you all of that. So giving you every single legally drafted document policy, including then the change management project you need to go through. So practically what you need to do step by step, which we can do because Helen and I have been in the industry and seen it all and done it all, and you know, that we can do that with a data privacy lawyer. But there are firms that do it, but it's, you know, those are kind of your options.
Got it. The next question here actually came up from a couple different people. But when we talk about individuals' rights and personal data, does that apply to clients as it does with candidates?
Yes, it does. Yeah. So it's kind of weird, isn't it? Because we sort of see them quite differently. But it's going back to this sort of human rights spirit. So it's like, you know, even a client is an individual. I think, you know, generally what we process on clients is, can be less detailed, maybe. So, you know, the bottom line is that it's a piece of legislation that applies to any individual. If they happen to be a client and happen to be a candidate, happen to be an employee, you know, it applies to all. But generally, I would say that, I don't know, I would say that people who want to see their data, I would think it's more likely to be your candidates than your clients. I think, you know, you have a different level of information on them. So, but it does apply to all of them.
Got it. And this is a good one, just to clarify, what exactly constitutes personal data? For example,
yes,
what a name, a job title, and a current company constitute as personal data?
Yeah, so it's got to be, whatever it is, it's got to identify somebody. So that one of the things they've changed is like the IP addresses. So that's now included. So it's information that will give away somebody's identity. So if you're John Smith at Tesco and that's all you've got, John Smith, Tesco, or I don't know, Adam Jones, Chrysler, I don't know, you know, just something like a massive firm that and a generic name, then that might not be enough to identify somebody. So you've got to have enough to be able to pinpoint a human being. So if you had John Smith, Chief Financial Officer, Tesco, then that person's readily identifiable, because Tesco only has one CFO. His name's John Smith and he works at Tesco. So, you know, it's all about how identifiable somebody is, which is why, you know, you might not need somebody's name, but you've got an IP address which is linked to them, so they're identifiable.
Got it. This is sort of a tricky one too. If someone submitted a request to erase their data, how are you supposed to have a record about deleting that individual data if you can't hold it? Does that make sense?
I know. I love this. I love this one. So one of the so again, it will depend on your country and its local laws and any issues it has about this. But one of the things that I think, so if we think this is about like human rights again, my view there would be, I mean, first of all, the right to erasure is, you know, it's a right that's linked to consent, albeit it can link to legitimate interest. If somebody objects and you can't fight why you've got it, then it'll lead to erasure. So let's say it's one of those scenarios. I think what I would practically do is I would try and speak to the person and I would say to them, in order, you know, what is it that you want from us? And if they would say, I just don't want to hear from you, I would say to them, the best thing for us to do is to continue to process your data under legitimate interest in order for us to not contact you. Because the thing with the right to erasure is it is only from the point in time back. So it's not prospective. So of course, if you do delete somebody's details, you're just as likely to find it the next day in the line of work we're in. So I would be tempted to speak to the person, understand what it is they want to get out of it, and I would probably then try and go with legitimate interest in order to then uphold their rights and what they want. But I do know that quite a lot of the software firms are looking at ways of, I'm not very technical, but basically from a technical perspective, how you can do this to save basically irritating people. You can erase their details, you can keep enough of an identifier so that not from a visible perspective for your consultants, but behind the database, there's a way of basically stopping the communication. I think that most people are quite reasonable, and actually if you were to contact them and they said, I don't want to hear from you, that if you said to them this is the best way of achieving it, they'd probably give you a chance at doing it, but you'd have to follow through then and make sure you didn't contact them again.
Right. There are definitely a couple questions around LinkedIn, and I guess this kind of pertains to any place where information is publicly available.
Yes.
And I guess in regards to the whole notion of transparency, if someone has their information on LinkedIn or say their website and it's publicly available data, I guess what extent can you have that, or how is that in your system without their consent?
Yeah, so you don't necessarily need their consent if you're relying on legitimate interest. So let's say we're relying on legitimate interest. But the thing is that, and this is the mindset change, is that just because my details are on LinkedIn, that I have not in my head anyway, I have not authorized for 15 search firms to have my details. Like I'm on LinkedIn because I want to connect with people, and so one of the adjustments we have to make is the fact that if we, irrespective of where we find it, if I'll come back to that point actually, but say you take somebody's details off LinkedIn, you put them onto your database because you think they're a great candidate and I want to reach out to them. You've started processing their data. The fact that you've got it from LinkedIn is what I would say it goes in your favor, that it's been sourced from a place that the person might expect you to find it. It's LinkedIn, it's a professional networking site. Same with job boards. So it doesn't change your responsibilities, but it's less contentious. One of the things for the industry that's a bit of a, that I think is interesting is when we're looking at all the different sorts of places we get data. We don't always get data from job boards and LinkedIn. Sometimes, I mean, when I used to research and find candidates in a very skill short market, I'd be looking everywhere, at all sorts of places, using the internet. And actually what's really interesting is that what the law says is that you should only be processing information sourced from places that the individual would reasonably expect you to find and then use the data. So if we look at other platforms that, I don't know, a community like software developer community, if we've somehow got access to that and found names and contact details, that isn't going to look very good, that we are then using that information. That would be a breach of somebody's sort of privacy. So it's quite an interesting area for discussion.
Definitely. Another question here. I guess if you're pulling a CV off of a job board, you have 30 days to gain consent from that person to share their data. Are you able to call and email them within that time frame? And if you don't get that consent, is it expected that you can't share the info with potential clients? Because I guess in this point, you're obviously in recruitment, you're acting in the interest of the candidate to try and place them. Yeah.
So this is where, straight back at you, Bullhorn, this is where I think that the software firms and the technology platforms, I think there is an opportunity here for your CRM, for example, to really help. So if people are adding people onto the database, it would be amazing from a recruitment context to have an automation, have some sort of automated response, because if somebody's adding somebody on and then there's an automatic email that goes, hey, we've got your details, we're keen to connect with you, blah, 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 blah. Here's our privacy policy. I think with recruitment, I'm more comfortable. I mean, it might be difficult practically because people are like, how are we going to do this with the amount of data that we kind of receive from a recruitment perspective? But I think it's doable because, like you say, either typically candidates are happy to be involved. So I don't see that as being such an issue. There might be people on the call who conduct executive search, and I think I would just say to them that the executive search process is obviously different to the recruitment process, and it's more covert. And we with what we do, we've thought at length about it. Helen and I have more recently been in the search industry, so the transparency element, I think, is harder for executive search than it is for recruitment. Really, for recruitment, it's process change, it's making sure your privacy policy is accessible in every which way you can possibly think of. But I think it's doable. I think it's much harder for executive search.
Got it. There are a couple questions on here, and I think this is just a good point to clarify as well. What roles do I guess firms play with regards to being a data processor versus a data controller? Could you maybe explain that a little bit?
Yeah, and this is a really good thing for you to ask, because we are observing a really interesting trend. So I will let everybody know about that. But a data controller is, as far as we see it, a data controller is an agency, a search firm, that you're a controller. So you process data for your business interest, you instigate it, you determine what that processing looks like, the purpose of it. You kind of control and own that process. A data processor is somebody, you might say that you outsource to, you might say somebody that's doing something on your behalf. So Bullhorn are a processor, you're not tampering or doing anything with the data that your customers have on your platform. You're providing them with a vehicle to make their lives easier in terms of their sort of, account management, customer relationships, etc., etc., etc. So controllers, so your clients are controllers, your controllers, and people you outsource to would be processors. Now, herein lies the nightmare that we seem to be facing, which is that, and I've worked in-house, so I'm gonna put my in-house hat on. One of the things that's a bit confusing, I think, if you're a client, is that if I've got a piece of work, I'm going to outsource it to an agency. So in my head, I'm a data controller, and I'm asking an agency to help me with a job. And as a client, I'm in my head thinking that the agency is a processor, and I get why clients are thinking like that. So there might be a lot of people nodding right now, but you possibly will be getting or have got information from your clients saying, what are you doing about GDPR? Are you doing these things? And then some clients are saying, when you do work for us, you will process it under consent. Now, I don't have an answer for how this is going to play out, but you are data controllers, but the challenge that you have is, depending on your client relationships, is how are you going to tackle that with your clients? Now, if you've got reasonable, perhaps smaller clients, or you've got good relationships where you can say, look, we're controllers. So what that means in English is that you're joint controllers. So they give you a piece of work, you do it, but you cultivate these relationships with people to enable to service your clients. You don't just go and create those relationships because that client's asked you to. So that's the key. So you've got to, what I would say to everybody listening is that you've got to get to your clients quickly and say to them, we're data controllers, this is how we do GDPR, this is how we're looking after the data, and try and get to them before they get to you, because they don't really, they have a right to dictate to you because they pay your bills, but they don't really have a right to dictate to you under GDPR. But I think our lawyer says everybody's so terrified about what's going on with GDPR and who's got what liability and who's responsible for what, that everybody's gone a bit contract crazy. And I think, you know, the bottom line is that we as recruiters, we have those relationships with candidates, and we don't just have them for a client's reason. We have them because this is what we do. So it's a really interesting, we're at a very interesting point. I don't know where we'll end up, but I would just strongly urge everybody listening to go and talk to their clients and say, we're data controllers, how can we get the right sort of contract in place, and educate them about that relationship.
Awesome. This might be sort of a loaded question, but a couple people had asked, just they've obviously started the efforts of these re-permissioning campaigns, going out to their candidates, trying to get their consent leading up to the 25th.
Yeah.
As far as the people that, like the candidates that don't respond to that, what's the expectation around what you do with all that information? Well,
the problem is that you don't well, first of all, you don't really want to be asking people to consent, is probably where I'd start there. So I think what I should say here, and I don't know what laws are like, because because I've only run recruitment businesses in the UK, so I don't know what the laws are like elsewhere. But in the UK, we've got something called the conduct regulations, and that's a piece of legislation that governs the conduct and behaviour of employment businesses, employment agencies. So what I need to stress here is that that piece of legislation says that when you are representing a candidate, you should either have the right to representation, i.e. they're consenting to you representing them, or they should be aware of where you're sending their details. But basically that's, you know, that's something that's another law, but they use the word consent, which, so GDPR is not precluding you from the right, you know, from doing all the things you'd normally do for the conduct regulations in terms of right of representation and getting somebody's permission to represent them, yada yada yada. What the GDPR, I think with GDPR, it's about transparency. It's about people knowing you've got their data and what you're doing with it, i.e. your privacy policy. And if you're relying on legitimate interest, you need to communicate with them. But you need evidence that you've communicated with them what you've communicated, but you don't, under legitimate interest, need them to okay that. You just need the evidence that you've been clear enough, that you've given them the opportunity in every which way you can think of to connect with your privacy policy. So that's kind of how we describe it. When you go for consent, the problem with consent is your consent will be invalid if you don't have a clear affirmative action from somebody. So consent's got a whole heap of requirements, and if you don't, so for example, if you sent out all these communications saying we need your consent and people don't reply, the bottom line is you don't have their consent. So
Right.
you know, you need them to be active, and that's why under GDPR consent's this much higher standard. It's very, very specific and rigid, and if you don't have it in the right way, it's not freely given, it's not informed, it's not unambiguous. If it's not those things, it's invalid. So it's quite a challenging, you know, it's a challenging lawful basis.
Right. Someone had kind of entered in an example of what they're doing, and I guess it'd be interesting to hear if other clients of yours are doing something like this as well. But if you're speaking to a potential candidate on the phone and you ask them to send over their CV, at that point, if you were to explain what your privacy policy is, or to send a thank you with maybe a link to that privacy policy, is that something that you're seeing people do?
Yeah, that's just it. I mean, when I look at it, I just think it's just polite. It's just polite, you know. What's been asked of us is what I would just describe as polite, you know, courteous behavior, you know. So you're on the phone to somebody, you know, and you can just say, I'm going to follow up with an email, and on there will be a link to our privacy policy, because obviously it's really important that you know what we do with your data. So, and it'll be as simple as that. You then send the email saying, hey, great conversation, really looking forward to talking to you more about this opportunity. You know, send me your details when you're ready. And then you'll say, you know, kind regards, Lucy, and then it'll say BULLHORN respects your privacy in the email footer, and then a link to, you know, your privacy policy, something like that.
I'm not sure that this has been explicitly outlined, but there are quite a few questions around like what duration of time you're allowed to hold on to information for, or like over what periods of time do you have to keep it up to date?
Yes, I know. This is so difficult. I mean, I think that the things I'd start thinking about, so only you will know the sector you work in, the level you work at, the services you offer. But you need to look at that, and then that will help you inform how long you can hold on to the data, along with how long will it go before you hand on heart can say, we're out of date here with that person. So I don't know, like if you were dealing in graduates, your whole business is based on graduates, you know, it would be hard. It's going to be hard to argue 4-year retention period, because a graduate 4 years later is going to look like a whole, you know, is going to be a completely different person. But if you worked, the sector I worked in was very skill short, engineering, you know, it was mid to senior level. You know, I'd have been more bullish about the retention period, because I'd have been like, seriously, there are only so many fire engineers in the country. I need to track them all. You know, so the skills shortages, the seniority, you know, how often do people move role? There's lots of things you can think about to help inform your decision around retention. But you just have to, you've got to have a logical argument. You can't just sort of, I mean, you could just say what you want and make it up and run the risk, but you know what they're looking for is that you've given it due consideration and you've come out, that you've calculated something and come out with a sensible answer. You know, I think, what am I seeing across clients? It does vary from executive search, as you'd expect, because it's at the senior level. You know, the more senior you go, arguably, the longer people are going to argue. The lower level you go, and the more junior you go, things change too quickly. So, you know, there's probably in the recruitment set, I mean, I don't know, I wouldn't say anybody's arguing more than 4 years, and I wouldn't say anybody's arguing less than a year. So it's somewhere in between. But what I will say is that I was listening to another webinar that a law firm did, and they did flag, and I want to say France and Holland, or basically some of the European countries, other European countries, may have really specific rules. And I want to say that she said something like, she was talking about it from an employer perspective, but she was saying that, I'm going to make this up, say it's France, it's probably not, but say it was France. It said something like that in France, you can only keep CVs of unsuccessful applicants for 30 days, and you can only extend it to 6 months with their permission, or something ridiculous like that. So you do have to know anything that your local, you know, anything that the country you're in, do they have any nuances around this? In the UK, there isn't anything like that, praise the Lord, but in some countries there might be. So just really to say, check that out.
Awesome. I know we're at the top of the hour, and I just wanted to end on one last question here. Obviously, there is an enormous amount of information to consume and processes to consider. What would your recommendation be to firms that are kind of just getting started? What is the first thing that they should? What's the first thing that they should do to tackle this?
I mean, I think what I said with the, you've got to draw a line in the sand. So you've got to know where you are today, because in terms of evidencing what you're trying to do to comply, anything that you do from your line in the sand forward is going to be a good thing. So for me, it's kind of like you need to understand where as a business have you got data and what data you've got, because if you don't know what you've got, you can have a privacy policy, but it's worth nothing if you don't actually have an understanding about the personal data you're processing, where it is, and that includes your staff. I mean, we one of the things we do early on with us is we do a data amnesty, which we send. It's a URL that goes out to all staff, and it asks them anonymously to admit where they've got data. And it's just you've got a responsibility as a business to know what have you got and where the hell is it. And I think that's where I'd start, and then what comes afterwards is then getting the ship in order. And with the best will in the world, it's going to be impossible for it to not cost money, and that's the truth of it. Whether you spend it with a lawyer, whether you spend it with a consultant, whether you spend it with us, to get what you need to get yourselves into good working order, it costs money. This is new legal advice, whatever. But I would definitely start with work out what you've got, where it is, and try and get a grip of it.
Yeah, awesome. Well, thank you again for helping prepare for today's discussion, and thank you for everyone for joining. Just a couple quick announcements. One, this has been recorded, and we'll make sure that everyone gets a copy of part 1 and part 2 here. Definitely register for the third. We'll make sure that link is available as well. And in terms of all the questions, I know there are a lot that were coming in, flooding in actually. So we'll do our best to kind of synthesize those and try to. Yes. And try to put those together in a blog or something that we can share with everyone as well. Thanks everyone for joining, and thank you, Lucy, very much.
Thank you. Thanks for having me.